Conclusions of law. Plaintiffs challenge Proposition 8 under the Due Process and Equal Protection Clauses of the 14th Amendment. Each challenge is independently meritorious, as Proposition 8 both unconstitutionally burdens the exercise of the fundamental right to marry and creates an irrational classification on the basis of sexual orientation. Due process. The Due Process Clause provides that no state shall deprive any person of life, liberty, or property without due process of law. United States Constitution, Amendment 14, Section 1. Due process protects individuals against arbitrary governmental intrusion into life, liberty, or property. Washington versus Glucksberg. When legislation burdens the exercise of a right deemed to be fundamental, the government must show the intrusion withstands strict scrutiny. Zablocki versus Redhale. The right to marry protects an individual's choice of marital partner regardless of gender. The freedom to marry is recognized as a fundamental right protected by the Due Process Clause. Turner v. Safely. The decision to marry is a fundamental right, and marriage is an expression of emotional support and public commitment. Zablocki. The right to marry is of fundamental importance for all individuals. Cleveland Board of Education versus LaFleur. This court has long recognized that freedom of personal choice in matters of marriage and family life is one of the liberties of the Due Process Clause of the 14th Amendment. Loving v. Virginia. The freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. Griswold versus Connecticut. Marriage is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. The parties do not dispute that the right to marry is fundamental. The question presented here is whether plaintiffs seek to exercise the fundamental right to marry, or, because they are couples of the same sex, whether they seek recognition of a new right. To determine whether a right is fundamental under the Due Process Clause, the court inquires into whether the right is rooted in our nation's history, legal traditions, and practices. Glucksberg. Here, because the right to marry is fundamental, the court looks to the evidence presented at trial to determine 1. The history, tradition, and practices of marriage in the United States, and 2. Whether the plaintiffs seek to exercise their right to marry or seek to exercise some other right. Marriage has retained certain characteristics throughout the history of the United States. Marriage requires two parties to give their free consent to form a relationship which then forms the foundation of a household. The spouses must consent to support each other at any independence. The state regulates marriage because marriage creates stable households, which in turn form the basis of a stable, governable populace. The state respects an individual's choices to build a family with another and protects the relationship because it is so central a part of the individual's life. Bowers v. Hardwick. Never has the state inquired into procreative capacity or intent before issuing a marriage license. Indeed, a marriage license is more than a license to have procreative sexual intercourse. It would demean a married couple were it said that marriage is simply about the right to have sexual intercourse. Lawrence. The Supreme Court recognizes that wholly apart from procreation, choice and privacy play a pivotal role in the marital relationship. Griswold. Race restrictions on marital partners were once common in most states, but now are seen as archaic, shameful, or even bizarre. When the Supreme Court invalidated race restrictions in Loving, the definition of the right to marry did not change. Indeed, the court recognized that race restrictions, despite their historical prevalence, stood in stark contrast to the concepts of liberty and choice inherent in the right to marry. The marital bargain in California, along with other states, traditionally required that a woman's legal and economic identity be subsumed by that of her husband under marriage under the doctrine of coverture. This once questioned aspect of marriage now is regarded as antithetical to the notion of marriage as a union of equals. The states moved to recognize the equality of the sexes. They eliminated laws and practices like coverture that had made gender a proxy for a spouse's role within a marriage. Marriage was thus transformed from a male-dominated institution into an institution recognizing women and men as equals. Yet individuals retained the right to marry. The right did not become different simply because the institution of marriage became compatible with gender equality. The evidence at trial shows that marriage in the United States traditionally has not been open to same-sex couples. The evidence suggests many reasons for this tradition of exclusion, including gender roles mandated through coverture, social disapproval of same-sex relationships, and the reality that the vast majority of persons are heterosexual and had no reason to challenge the restriction. The evidence shows that the movement of marriage away from a gendered institution and toward an institution free from state-mandated gender role reflects an evolution in the understanding of gender rather than a change in marriage. The evidence did not show any historical purpose for excluding same-sex couples from marriage, as states have never required spouses to have an ability or willingness to procreate in order to marry. Rather, the exclusion exists as an artifact of a time when genders were seen as having distinct roles in society and in marriage. That time has passed. The right to marry has been historically and remains the right to choose a spouse and, with mutual consent, join together to form a household. Race and gender restrictions shaped marriage during eras of race and gender equality, but such restrictions were never part of the historical core of the institution of marriage. Today, gender is not relevant to the state in determining spouses' obligations to each other and to the dependents. Relative gender compensation aside, same-sex couples are situated identically to opposite-sex couples in terms of their ability to perform the rights and obligations of marriage under California law. Gender no longer forms an essential part of marriage. Marriage under law is a union of equals. Plaintiffs seek to have the state recognize their committed relationships, and plaintiffs' relationships are consistent with the core of the history, tradition, and practice of marriage in the United States. Perry and Steyer seek to be spouses. They seek the mutual obligation and honor that attend marriage. Zarrillo and Katami seek recognition from the state that their union is a coming together for better or for worse, hopefully enduring, intimate to the degree of being sacred. Plaintiffs' unions encompass the historical purpose and form of marriage. Only the plaintiffs' genders relative to one another prevent California from giving their relationships due recognition. Plaintiffs do not seek recognition of a new right. To characterize plaintiffs' objective as the right to same-sex marriage would suggest that plaintiffs seek something different from what opposite-sex couples across the state enjoy, namely marriage. Rather, plaintiffs ask California to recognize their relationship for what they are, marriages. Domestic partnerships do not satisfy California's obligation to allow plaintiffs to marry. Having determined that plaintiffs seek to exercise their fundamental right to marry under the Due Process Clause, the court must consider whether the availability of registered domestic partnerships fulfills California's due process obligation to same-sex couples. The evidence shows that domestic partnerships were created as an alternative to marriage that distinguished same-sex from opposite-sex couples in remarriage cases. One of the core elements of the fundamental right to marry is the right of same-sex couples to have their official family relationships accorded the same dignity, respect, and stature as that accorded to all other officially recognized family relationships. By reserving the historic and highly respected designation of marriage exclusively to opposite-sex couples, while offering same-sex couples only the new and unfamiliar designation of domestic partnership, the state communicates the official view that same-sex couples committed to relationships are of less stature than the comparable relationships of opposite-sex couples. Proponents do not dispute the significant symbolic disparity between domestic partnership and marriages. California has created two separate and parallel institutions to provide couples with essentially the same rights and obligations. California Family Code, Section 297.5a. Domestic partnerships are not open to opposite-sex couples unless one partner is at least 62 years old. California Family Code 297b5. Apart from this limited exception, created especially to benefit those eligible for benefits under the Social Security Act, the sole basis upon which California determines whether a couple receives the designation married or the designation domestic partnership is the sex of the spouses relative to one another. Compare the California Family Code 297 to 299.6 domestic partnership with sections 300 to 536, the definition of marriage. No further inquiry into the couple or the couple's relationship is required or permitted. Thus, California allows almost all opposite-sex couples only one option, marriage, and all same-sex couples only one option, domestic partnership. The evidence shows that domestic partnerships do not fulfill California's due process obligation to plaintiffs for two reasons. First, domestic partnerships are different from marriage and do not provide the same social meaning as marriage. Second, domestic partnerships were created specifically so that California could offer same-sex couples rights and benefits while explicitly withholding marriage from same-sex couples. Governor Davis, in his signing statement, said, "In California, legal marriage is between a man and a woman. This domestic partnership legislation does nothing to contradict or undermine the definition of legal marriage." The evidence at trial shows that domestic partnerships exist solely to differentiate same-sex unions from marriage. A domestic partnership is not a marriage. While domestic partnerships offer same-sex couples almost all of the rights and responsibilities associated with marriage, the evidence shows that the withholding of the designation marriage significantly disadvantages the plaintiffs. The record reflects that marriage is a culturally superior statute compared to a domestic partnership. California does not meet its due process obligation to allow plaintiffs to marry by offering them a substitute and inferior institution that denies marriage to same-sex couples. Proposition 8 is unconstitutional because it denies plaintiffs a fundamental right without a legitimate, much less compelling, reason. Because plaintiffs seek to exercise their fundamental right to marry, their claim is subject to strict scrutiny, Zablocki. That the majority of California voters supported Proposition 8 is irrelevant, as fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. West Virginia State Board of Education versus Barnett. Under strict scrutiny, The state bears the burden of producing evidence to show that Proposition 8 is narrowly tailored to a compelling government interest. Because the government defendants decline to advance such arguments, proponents seize the role of asserting the existence of a compelling California interest in Proposition 8. As explained in detail in the Equal Protection Analysis, Proposition 8 cannot withstand rational basis review. Still less can Proposition 8 survive the strict scrutiny required by plaintiffs' due process claim. The minimal evidentiary presentation made by the proponents does not meet the heavy burden of production necessary to show that Proposition 8 is narrowly tailored to a compelling government interest. Proposition 8 cannot therefore withstand strict scrutiny. Moreover, proponents do not assert that the availability of domestic partnerships satisfies plaintiffs' fundamental right to marry. Proponents stipulated that there is a significant symbolic disparity between domestic partnership and marriage. Accordingly, Proposition 8 violates the Due Process Clause of the 14th Amendment. Equal protection. The Equal Protection Clause of the 14th Amendment provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. United States Constitution, Amendment 14, Section 1. Equal protection is a pledge of the protection of equal laws. Yquo v. Hopkins. The guarantee of equal protection coexists, of course, with the reality that most legislation must classify for some purpose or other. See Romer v. Evans. When a law creates a classification, but neither targets a suspect class nor burdens a fundamental right, the court presumes the law is valid and will uphold it as long as it is rationally related to some legitimate government interests. Heller v. Doe. The court defers to legislative, or in this case, popular judgment, if there is at least a debatable question whether the underlying basis for the classification is rational. Minnesota v. Cloverleaf Creamery Company. Even under the most deferential standard of review, however, the court must insist on knowing the relationship between the classification adopted and the object to be obtained. Romer, Heller. Basis for classification must find some footing in the realities of the subject addressed by the legislation. The court may look to evidence to determine whether the basis for the underlying debate is rational. Plyler v. Doe. Finding an asserted interest in preserving state resources by prohibiting undocumented children from attending public school to be irrational because the available evidence suggests that illegal aliens underutilize public services while contributing their labor to the local economy and tax money to the state. The search for a rational relationship, while quite deferential, ensures that classifications are not drawn for the purpose of disadvantaging the group burdened by the law. The classification itself must be related to the purported interest. It is difficult to conceive a rational basis for penalizing undocumented children for their presence within the United States, despite the state's interest in preserving resources. Most laws subject to rational basis easily survive equal protection review because a legitimate reason can nearly always be found for treating different groups in an unequal manner. See Romer. Yet to survive a rational basis review, a law must do more than disadvantage or otherwise harm a particular group. United States Department of Agriculture v. Moreno. Sexual orientation or sex discrimination. Plaintiffs challenge Proposition 8 as violating the Equal Protection Clause because Proposition 8 discriminates both on the basis of sex on the basis of sexual orientation. Sexual orientation discrimination can take the form of sex discrimination. Here, for example, Perry is prohibited from marrying Steyer, a woman, because Perry is a woman. If Perry were a man, Proposition 8 would not prohibit the marriage. Thus, Proposition 8 operates to restrict Perry's choice of marital partner because of her sex. But Proposition 8 also operates to restrict Perry's choice of marital partner because of her sexual orientation. Her desire to marry another woman arises only because she is a lesbian. The evidence at trial shows that gays and lesbians experience discrimination based on unfounded stereotypes and prejudices specific to sexual orientation. Gays and lesbians have historically been targeted for discrimination because of their sexual orientation. That discrimination continues to be present. As the case of Perry and the other plaintiffs illustrate, sex and sexual orientation are necessarily interrelated, as an individual's choice of romantic or intimate partner on sex is a large part of what defines an individual's sexual orientation. Sexual orientation discrimination is thus a phenomenon distinct from, but related to, sex discrimination. Proponents argue that Proposition 8 does not target gays or lesbians because its language does not refer to them. In so arguing, proponents seek to mask their own initiative. Those who choose to marry someone of the opposite sex, heterosexual, do not have their choice of marital partners restricted by Proposition 8. Those who would choose to marry someone of the same sex, homosexual, have had their right to marry eliminated by an amendment to the state constitution. Homosexual conduct and identity together define what it means to be gay or lesbian. Indeed, homosexual conduct and attraction are constitutionally protected and integral parts of what makes someone gay or lesbian. Lawrence. See also Christian Legal Society versus Martinez. Our decisions have declined to distinguish between status and conduct in the context of sexual orientation. Citing Lawrence. Proposition 8 targets gays and lesbians in a manner specific to their sexual orientation and because of their relationship to one another. Proposition 8 targets them specifically due to sex. Having considered the evidence, the relationship between sex and sexual orientation, and the fact that Proposition 8 eliminates a right only a gay man or lesbian would exercise, the court determines that plaintiff's equal protection claim is based on sexual orientation, but this claim is equivalent to a claim of discrimination based on sex. Standard of review. As presently explained in detail, the Equal Protection Clause renders Proposition 8 unconstitutional under any standard of review. Accordingly, the court need not address the question whether laws classifying on the basis of sexual orientation should be subject to a heightened standard of review. Although Proposition 8 fails to possess even a rational basis, the evidence presented at trial shows that gays and lesbians are the type of minority strict scrutiny was designed to protect. Massachusetts Board of Retirement versus Murguia. Noting that strict scrutiny may be appropriate where a group has experienced a history of purposeful, unequal treatment or has been subjected to unique disabilities on the basis of stereotyped characteristics not truly indicative of their abilities. Quoting San Antonio School District versus Rodriguez. Proponents admit that same-sex sexual orientation does not result in any impairment in judgment or general social or vocational capabilities. The court asked the parties to identify a difference between heterosexuals and homosexuals that the government might fairly need to take into account when crafting legislation. Proponents pointed only to a difference between same-sex couples who are incapable through sexual intercourse of producing offspring biologically related to both partners and opposite-sex couples some of whom are capable through sexual intercourse of producing such offspring. Proponents did not, however, advance any reason why the government may use sexual orientation as a proxy for fertility, or why the government may need to take into account fertility when legislating. Consider, by contrast, City of Cleburne versus Cleburne Living Center. Legislation singling out a class for differential treatment hinges upon a determination of, quote, real and undeniable differences, close quote, between the class and others. And see also United States versus Virginia. Quote, physical differences between men and women are enduring, close quote. No evidence at trial illuminated distinctions among lesbians, gay men, and heterosexual amounting to, quote, real and undeniable differences, close quote, that the government might need to take into account in legislating. The trial record shows that strict scrutiny is the appropriate standard of review to apply to legislative classifications based on sexual orientation. All classifications based on sexual orientation appear suspect, as the evidence shows that California would rarely, if ever, have a reason to categorize individuals based on their sexual orientation. Here, however, strict scrutiny is unnecessary. Proposition 8 fails to survive even rational basis review. Proposition 8 does not survive rational basis. Proposition 8 cannot withstand any level of scrutiny under the Equal Protection Clause, as excluding same-sex couples from marriage is simply not rationally related to a legitimate state interest. One example of a legitimate state interest in not issuing marriage licenses to a particular group might be a scarcity of marriage licenses or county officials to issue them. But marriage licenses in California are not in limited commodity, and the existence of 18,000 same-sex married couples in California shows that the state has the resources to allow both same-sex and opposite-sex couples to wed. Proponents put forth several rationale for Proposition 8, which the Court now examines in turn. 1. Reserving marriage as a union between a man and a woman and excluding any other relationship from marriage. 2. Proceeding with caution when implementing social changes. 3. Promoting opposite-sex parenting over same-sex parenting. 4. Protecting the freedom of those who oppose marriage from same-sex couples. 5. Treating same-sex couples differently from opposite-sex couples. And 6. Any other conceivable interest. Purported interest number 1. Reserving marriage as a union between a man and a woman and excluding any other relationship. Proponents first argued that Proposition 8 is rational because it, 1, preserves the traditional institution of marriage as a union of a man and a woman. 2, the traditional social and legal purposes, functions, and structures of marriage. And 3, the traditional meaning of marriage as it has always been defined in the English language. These interests relate to maintaining the definition of marriage as a union of a man and a woman for its own sake. Tradition alone, however, cannot form a rational basis for a law. Williams versus Illinois. The ancient lineage of a classification does not make it rational. Heller. Rather, the state must have an interest apart from the fact of the tradition itself. The evidence shows that the tradition of restricting an individual's choice of spouse based on gender does not rationally further a state interest despite its ancient lineage. Instead, the evidence shows that the tradition of gender restrictions arose when spouses were legally required to adhere to specific gender roles. California has eliminated all legally mandated gender roles except for the requirement that a marriage consist of a man and one woman. Proposition 8 thus enshrines in the California Constitution a gender restriction that the evidence shows to be nothing more than an artifact of a foregone notion that men and women fulfill different roles in civic life. The tradition of restricting marriage to opposite-sex couples does not further any state interest. Rather, the evidence shows that Proposition 8 harms the state's interest in equality because it mandates that men and women be treated differently based only on antiquated and discredited notions of gender. Proponents argue that tradition prefers opposite-sex couples to same-sex couples, equates to the notion that opposite-sex relationships are simply better than same-sex relationships. Tradition alone cannot legitimate this purported interest. Plaintiffs presented evidence showing conclusively that the state has no interest in preferring opposite-sex couples to same-sex couples or in preferring heterosexuality to homosexuality. Moreover, the state cannot have an interest in disadvantaging an unpopular minority group simply because the group is unpopular. Moreno. The evidence shows that the state advances nothing when it adheres to the tradition of excluding same-sex couples from marriage. Proponents asserted state interests in tradition are nothing more than tautologies and do not amount to rational bases for Proposition 8. Purported interest, number 2, proceeding with caution when implementing social changes. Proponents next argue that Proposition 8 is related to state interests in 1. Acting incrementally and with caution when considering a radical transformation to the fundamental nature of a bedrock social institution. That's a quote. And 2, quote, decreasing the probability of weakening the institution of marriage, unquote. 3, quote, decreasing the probability of adverse consequences that could result from weakening the institution of marriage, close quote. And 4, quote, decreasing the probability of a potential adverse consequences of same-sex marriage, close quote. Plaintiffs presented evidence at trial sufficient to rebut any claim that marriage for same-sex couples amounts to a sweeping social change. Instead, the evidence shows beyond debate that allowing same-sex couples to marry has at least a neutral, if not a positive, effect on the institution of marriage, and that same-sex couples' marriages would benefit the state. Moreover, the evidence shows that the rights of those opposed to homosexuality or same-sex couples will remain unaffected if the state ceases to enforce Proposition 8. The contrary evidence proponents presented is not credible. Indeed, proponents presented no reliable evidence that allowing same-sex couples to marry will have any negative effects on society or on the institution of marriage. The process of allowing same-sex couples to marry is straightforward, and no evidence suggests that the state needs any significant lead time to integrate same-sex couples into marriage. Consider by contrast Cooper v. Aaron. Recognizing that a school district needed time to implement racial integration, but nevertheless finding a delay unconstitutional because the school board's plan did not provide for, quote, the earliest practicable completion of desegregation, unquote. The evidence shows that allowing same-sex couples to marry will be simple for California to implement because it has already done so. and no change need be phased in. California need not restructure any institution to allow same-sex couples to marry. Because the evidence shows same-sex marriage has and will have no adverse effects on society or on the institution of marriage, California has no interest in waiting and no practical need to wait to grant marriage licenses to same-sex couples. Proposition 8 is thus not rationally related to proponents' purported interest in proceeding with caution when implementing social change. Purported interest number 3, promoting opposite-sex parenting over same-sex parenting. Proponents' largest group of purported state interest relates to opposite-sex parents. Proponents argue Proposition 8 promotes stability and responsibility in naturally procreative relationships. 2. Promotes enduring and stable family structures for the responsible raising and care of children by their biological parents. 3. Increases the probability that natural procreation will occur within stable, enduring, and supporting family structures. 4. Promotes the natural and mutually beneficial bond between parents and their biological children. 5. Increases the probability that each child will be raised by both of his or her biological parents. 6. Increases the probability that each child will be raised by both a father and a mother. And 7. Increases the probability that each child will have a legally recognized father and mother. The evidence supports 2 points which together show Proposition 8 does not advance any of the identified interests. 1. Same-sex parents and opposite parents are of equal quality. And 2. Proposition 8 does not make it more likely that opposite-sex couples will marry and raise offspring biologically related to both parents. The evidence does not support a finding that California has an interest in preferring opposite-sex parents over same-sex parents. Indeed, the evidence shows beyond any doubt that parents' genders are irrelevant to the children's developmental outcomes. Moreover, Proposition 8 has nothing to do with children, as Proposition 8 simply prevents same-sex couples from marrying. Same-sex couples can have or adopt and raise children. When they do, they're treated identically to opposite-sex couples under California law. Even if California had an interest in preferring opposite-sex parents to same-sex parents, and the evidence plainly shows that California does not, Proposition 8 is not rationally related to that interest, because Proposition 8 does not affect who can or who should become a parent under California law. To the extent that California has an interest in encouraging sexual activity to occur within marriage, a debatable proposition in light of Lawrence, the evidence shows Proposition 8 to be detrimental to that interest, because Proposition 8, same-sex couples are not permitted to engage in sexual activity within marriage. Domestic partnerships, in which sexual activity is apparently expected, are separate from marriage and thus modify California's encouragement of non-marital sexual activity. To the extent that proponents seek to encourage a norm that sexual activity occur within marriage to ensure that reproduction occurs within stable household, Proposition 8 discourages that norm because it requires some sexual activity and childbearing and child rearing to occur outside of marriage. Proponents argue Proposition 8 advances a state interest in encouraging the formation of stable households. Instead, the evidence shows that Proposition 8 undermines that state interest because same-sex households have become less stable by the passage of Proposition 8. The inability to marry denied same-sex couples that benefit, including stability attendant to marriage. Proponents fail to put forth any credible evidence that married opposite-sex households are made more stable through Proposition 8. The only rational conclusion, in light of the evidence that Proposition 8 makes it less likely that California children will be raised in stable households. None of the interests put forth by the proponents relating to parents and children is advanced by Proposition 8. Instead, the evidence shows Proposition 8 disadvantages families and their children. Purported interest number 4, protecting the freedom of those who oppose marriage for same-sex couples. Proponents next argue that Proposition 8 protects the First Amendment freedom of those who disagree with allowing marriages for couples of the same sex. Proponents argue that Proposition 8.1 preserves the prerogative and responsibility of parents to provide for the ethical and moral development and education of their own children, and 2, accommodates the First Amendment rights of individuals and institutions that oppose same-sex marriage on religious or moral grounds. These purported interests fail as a matter of law. Proposition 8 does not affect any First Amendment right or responsibility of parents to educate their children. Californians are prevented from distinguishing between same-sex partners and opposite-sex partners in public accommodations, as California's anti-discrimination law requires identical treatment for same-sex unions and opposite-sex marriage. The evidence shows that Proposition 8 does nothing other than eliminate the right of same-sex couples to marry in California. Proposition 8 is not rationally related to an interest in protecting the rights of those opposed to same-sex couples because, as a matter of law, Proposition 8 does not affect the rights of those opposed to homosexuality or to marriage for couples of the same sex. To the extent proponents argue that one of the rights of those morally opposed to same-sex unions is the right to prevent same-sex couples from marrying, as explained presently, those individuals' moral views are an insufficient basis upon which to enact a legislative classification. Purported interest number 5, treating same-sex couples differently than opposite-sex couples. Proponents argue that Proposition 8 advances a state interest in treating same-sex couples differently from opposite-sex couples by using different names for different things. 2, maintaining the flexibility to separately address the needs of different types of relationships. 3, ensuring that California marriages are recognized in other jurisdictions. And 4, conforming California's definition of marriage to federal law. Here proponents assume a premise that the evidence thoroughly rebutted rather than being different. Same-sex and opposite-sex unions are, for all purposes relevant to California law, exactly the same. The evidence shows conclusively that moral and religious views form the only basis for a belief that same-sex couples are different from opposite-sex couples. The evidence fatally undermines any purported state interest in treating couples differently. Thus, those interests do not provide a rational basis supporting Proposition 8. In addition, proponents appear to claim that Proposition 8 advances a state interest in easing administrative burdens associated with issuing and recognizing marriage licenses. Under precedents such as Craig v. Boren, administrative ease and convenience are not important government objectives. Even assuming that the state were to have an interest in administrative convenience, Proposition 8 actually creates an administrative burden on California because California must maintain a parallel institution for same-sex couples to provide the equivalent rights and benefits afforded to married couples. Domestic partnerships create an institutional scheme that must be regulated separately from marriage. California may determine whether to retain domestic partnerships or eliminate them in the absence of Proposition 8. The court presumes, however, that as long as Proposition 8 is in effect, domestic partnerships and the accompanying administrative burden will remain. Proposition 8 thus hinders rather than advances administrative convenience. Purported interest number 6, the catch-all interests. Finally, proponents assert that Proposition 8 advances any other conceivable legitimate interests identified by the parties, or the amici brief, or the court at any stage of the proceedings. But proponents, amici, and the court, despite ample opportunity and a full trial, have failed to identify any rational basis Proposition 8 could conceivably advance. Proponents, represented by able and energetic counsel, developed a full trial record in support of Proposition 8. The resulting evidence shows that Proposition 8 simply conflicts with the guarantees of the 14th Amendment. Many of the purported interests identified by proponents are nothing more than a fear or unarticulated dislike of same-sex couples. Those interests that are legitimate are unrelated to the classifications drawn by Proposition 8. The evidence shows that by every available metric, opposite-sex couples are not better than their same-sex counterparts. Instead, as partners, parents, and citizens, opposite-sex couples and same-sex couples are equal. Proposition 8 violates the Equal Protection Clause because it does not treat them equally. A private moral view that same-sex couples are inferior to opposite-sex couples is not a proper basis for legislation. In the absence of a rational basis, what remains a proponent's case is an inference, amply supported by evidence and the record that Proposition 8 was premised on the belief that same-sex couples are simply not as good as opposite-sex couples. Whether that belief is based on moral disapproval of homosexuality, animus towards gays and lesbians, or simply a belief that a relationship between two men or two women, that a relationship between a man and a woman is inherently better than a relationship between two men or two women, this belief is not a proper basis on which to legislate. See Romer, Moreno, Palmore versus Sedati. The Constitution cannot control private biases, but neither can it tolerate them. The evidence shows that Proposition 8 was a hard-fought campaign, and the majority of California voters supported the initiative. The arguments surrounding Proposition 8 raise a question similar to that in Lawrence when the court asked whether a majority of citizens could use the power of the state to enforce profound and deep convictions accepted as ethical and moral principles through the criminal code. The question here is whether California voters can enforce the same principles through regulation of marriage licenses. They cannot. California's obligation is to treat its citizens equally, not to mandate its own moral code. Moral disapproval without any other asserted state interest has never been a rational basis for legislation. Lawrence. Tradition alone cannot support legislation. Williams, Romer, Lawrence. Proponents' purported rationale are nothing more than post hoc justifications. While the Equal Protection Clause does not prohibit post hoc justifications and rationales, they must connect to the classifications drawn. Here, the purported state interests fit so poorly with Proposition 8 that they are irrational, as explained above. What is left is evidence that Proposition 8 enacts a moral view that there is something wrong with same-sex couples. The evidence at trial regarding the campaign to pass Proposition 8 uncloaks the most likely explanation for its passage, a desire to advance the belief that opposite-sex couples are morally superior to same-sex couples. The campaign relied heavily on negative stereotypes amongst gays and lesbians and focused on protecting children from in-choke threats vaguely associated with gays and lesbians? Video. Have you thought about it? Video of a young girl asking whether the viewer has considered the consequences to her of Proposition 8, but not explaining what those consequences might be. At trial, proponents' counsel attempted, through cross-examination, to show that the campaign wanted to protect children from learning about same-sex marriage in school. Ron Prentice addressing supporters of Proposition 8. Plaintiff's counsel to Katami. But the fact is that what the Yes on 8 campaign was pointing at is that kids would be taught about same-sex relationships in first and second grade. Isn't that a fact? That's what they were referring to. The evidence shows, however, that Proposition 8 played on a fear that exposure to homosexuality would turn children into homosexuals, and that parents should dread having children who are not heterosexual. A video, it's already happened, mother's expression of horror upon realizing her daughter now knows she can marry a princess. The testimony of George Chauncey places the Protect Marriage campaign advertisements in historical context as echoing messages from previous campaigns to enact legal measures to disadvantage gays and lesbians. The Protect Marriage campaign advertisement ensured California voters had those previous fear-inducing messages in mind. The evidence at trial shows those fears to be completely unfounded. Moral disapproval alone is an improper basis on which to deny rights to gays and lesbians. The evidence shows conclusively that Proposition 8 enacts without reason a private moral view that same-sex couples are inferior to opposite-sex couples. Romer. Laws of the kind now before us raise the inevitable inference that the disadvantage imposed is born of animosity towards the class of persons affected. Because Proposition 8 disadvantages gays and lesbians without any rational justification, Proposition 8 violates the Equal Protection Clause of the 14th Amendment. Conclusion. Proposition 8 fails to advance any rational basis in singling out gay men and lesbians for denial of a marriage license. Indeed, the evidence shows Proposition 8 does nothing more than enshrine in the California Constitution the notion that opposite-sex couples are superior to same-sex couples. Because California has no interest in discriminating against gay men and lesbians, and because Proposition 8 prevents California from fulfilling its constitutional obligation to provide marriages on an equal basis, the court concludes that Proposition 8 is unconstitutional. Remedies. Plaintiffs have demonstrated by overwhelming evidence that Proposition 8 violates their due process and equal protection rights, and that they will continue to suffer those constitutional violations until state officials cease enforcement of Proposition 8. California is able to issue marriage licenses to same-sex couples as it has already issued 18,000 marriage licenses to same-sex couples and has not suffered any demonstrated harm as a result. Moreover, California officials have chosen not to defend Proposition 8 in these proceedings. Because Proposition 8 is unconstitutional under both the due process and equal protection clauses, the court orders entry of judgment permanently enjoining its enforcement, prohibiting official defendants from applying or enforcing Proposition 8, and directing the official defendants that all persons under their control or supervision shall not apply or enforce Proposition 8. The clerk is directed to enter judgment without bond in favor of plaintiffs and plaintiff interveners and against defendants and defendant interveners pursuant to FRCP 58. It is so ordered. Vaughn R. Walker, United States District Chief Judge.